Ramaphosa, whether they can recall in living memory anything of the scale of what happened on the 16th. All of them agreed. It is the kind of happening that reminded them of Sharpeville, of Langa, of Boipatong, and all those events in our dark history in the past that were referred to as massacres. And almost 20 years into our democracy, we had a massacre of that scale. And therefore, there lies the question. And at the end of these proceedings, Mr. Chairman, I will try and demonstrate that it cannot be done in the name of democracy. That there needed to be no equivocation either from Minister Mthethwa or Deputy President Ramaphosa about the fact that what happened, certainly on the 16th, I'm not saying anything about what went on the 13th because I'm going to get into that detail, the extrajudicial killings in our submissions. What happened just ought not to have happened. When we submit, Mr. Chair, that in both Scene 1 and Scene 2, especially on the 16th, the killings on the 16th. These are killings that take place after a plan was conceived. But more importantly, the day before, 4,000 rounds of ammunition, sharp ammunition, are ordered.
That's correct. They were ordered on the day.
On the day.
That's the evidence. And when they arrive, and there's a dispute, as you know, as to whether
yes.
Brigadier Khalid ordered them or whether it was Colonel Marafi is doing it himself without instruction from
yes.
Brigadier Khalid. And the evidence is when they arrived at the dock, Brigadier Pretoria sent them back. But the significance of the fact that they were ordered indicates that some senior official, senior officer, foresaw the possibility, at least, of serious fire battle involving a substantial amount of bullets and so on.
Yes. Thank you, Mr. Chairman. And of course, 4 mortuary vans are ordered. Now, the evidence that will draw your attention to shows that most, if not all, of the people who were killed by high velocity R5 rifle gunfire. Now, in our heads of argument, I think in paragraphs if I could get there, Mr. Chairman. Warrant officer, the one who passed off, yes. In paragraph 334, in fact from 335, warrant officer Vessels testifies as to what effect an R5 rifle has. He is being asked, my intention is just to get an unequivocal statement from you, if it is possible, that agrees with me that when once you bring R1 rifles and R5 rifles to a scene, you are likely to incur fatalities because those are lethal weapons intended to kill. Warrant Officer Vessel says, I will agree with you later. And you yourself, Mr. Chairman, take it up and you say, Sorry to interrupt you. Isn't the expression assault rifles? Have you ever come across that expression, assault rifle? Warrant Officer Vessel, assault rifle is the correct. Now R4s and R5s, assault rifles, vessels, they conform to the description of an assault rifle. Chairperson, you are then on the battlefield. You use them on the battlefield to kill the enemy, don't you? That is correct. We will be making further submissions about the use of those kinds of things. Now, the rover who came as the expert by the South African Police Services has this to say, and we recall it in the heads. In 335.2, Mr. Chairman. But at least in understanding the risks these weapons pose, and I'll be more specific, that a 5.56 round fired at close range is virtually, in per definition, a kill shot. It doesn't even matter where on the body you hit. Because if you strike, the problem is with the fact that the bullet on impact disintegrates because of the high kinetic energy it carries. And then lower down, virtually the last paragraph where it starts with but. But at close range, that bullet shatters on impact and it produces horrific wounds. If you get hit on the arm, you are likely losing that arm. If you get hit center body mass, you get a wound cavity from what I understand to be 20 centimeters across. So your chance of survival are minimal. So when we say these people were killed, Mr. Chairman, we can talk about technical terms. Because I'm a lawyer, I'm supposed also to lay the tests and what have you. But these families have heard what Warrant Officer Vessels was saying was the effect of what an R5 rifle does. And these families have heard what expert witness Tirova says is the devastating effect of R5 rifles, especially at close range. And then they will ask the question, was there no other way? I'm assuming at this stage that it is accepted that the police had reason to believe that they were being attacked, that they were protecting themselves. The question the people will want to know, was this the way? And Mr. Chair, as we then proceed, we want to do at least 6 things. First of all, there will be argument which I think my learned friend Mr. Mpofu will be making with respect to the principles of putative self-defense, which is a product of a joint effort made by our legal team, the legal teams of LRC, SHRC, on AMCO. I'm not properly advised, Mr. Chairman. But yes, So there is that. I believe that it was handed up, and if it wasn't, at least there was an indication.
But I take it we're going to be getting it in due course. And
Indeed.
looking forward to getting it. And it seems quite a powerful combination of people have been involved in preparing it, so all the more reason to read it with eager anticipation.
But if I may just say this, Mr. Chair, we want to address you on a couple of things. The first one is, what is the standard of proof that you should adopt in determining the lawfulness or otherwise of the killings? Insofar as you have had extensive argument from the SHRC on this point, which we are endorsing, namely that the onus is on the police service to justify each shot, to justify each killing. And where they are not able to do so, the killing must then be found to have been unlawful. Because any other approach would, in any event, as I understood the submissions, inconsistent with the fundamental right to life and with the domestic civil standard of proof in relation to alleged unlawful killings. Then we'd like to spend a little more time, Mr. Chair, on the killings that took place on the 13th of August, 2012. But in relation to that, I have to say there has been a lot of submissions that were made both by the evidence leaders and everybody else. And it seems to us that rather than saturating that area with further argument, we can make the following summary of what we understand the essential issues are relevant to that, except that we will now give you more detail with respect to the killing of Mr. Jokanisi and the killing of Mr. Mati, and to the extent that there is still any equivocation, the killing of Mr. Sokanyil. But relevant to the 13th, we summarize our submissions as follows. One, it is clear to us that the strikers were walking peacefully in the direction of the Kopi when there was this unprovoked attack on them by means of tear gas and stun grenades. And it is so even though they had not changed the direction towards the informal settlements. That much is even testified to by Kenneth Mark. And our submission is that the subsequent discharge of tear gas and stun grenades by the SAPS was thus without reason, unprovoked and unnecessary. And it is in our submission this unprovoked attack by means of tear gas and stun grenades which caused the confrontation between the SAPS and the strikers and the deaths that ensued. And we make the submission that on that basis the SAPS must be held liable for all the deaths that occurred on that day. Where we want to spend a little more detail is with the aid of this new post-mortem report which I referred to. Mr. Chairman, you will know that Mr. Joganis is the striker who was shot and killed on the same field when where the main confrontation took place, albeit from a distance from it. We have made the submission that he was unlawfully killed by the SAPS. They have not provided any justification or any explanation regarding the circumstances in which Mr. Johannessi was killed. In fact, they simply argue, based on alleged proximity of Mr. Johannes's body to that of Warrant Officer Lepaku, that it is fair to infer that his death must have been the result of police response to an attack on the police by him or his fellow strikers.
Mr. Bezo, I take it we'd better mark these exhibits that you're handing in.
Yes, Mr. Chair.
For the sake of order and so on. No, we did have a document earlier in respect of Mr. Jokansi that we marked, according to my notes, quadruple Z 33. So that's already before us, unless this is a new document about him.
I'm instructed it's the same, Mr. Chair.
All right. Yes, it's bigger. It's easier for those of us with tired eyes to read it. A4 paper as well. So that's, what did I say? That was...
Chair, that's quadruple Z33, and quadruple Z34 is the report in respect of Mr. Sokanile. Dr. Naidu's report in respect of Mr. Sokanile.
All right. We've got these are now clearer copies for us, for the benefit of those parties who need larger print. Okay. And then you've also got a lot of other things that you've given us. Other documents as well. If they're not exhibits, they can be marked. But perhaps to save your time, we can ask Ms. Pillay to perform her usual highly efficient services for us during the tea adjournment and mark them in, so we don't waste your time now.
Thank you, Mr. Chair. I'm sure Ms. Pillay will confirm. Now, Mr. Chair, we say there's no justification that has been provided by, or explanation. The nearest by means of an explanation that we get is that they draw an inference that his death must have been the result of police response to an attack on the police by him or his fellow strikers. So they do not even allege that Mr. Jokanisi was involved in the attack on Warrant Officer Lepako. They make the assumption that his or one of those fellow strikers was. And we submit that this is clearly not sufficient to discharge their burden of justifying his killing. We therefore call upon the Commission to find that on this basis alone, the failure to justify the killing of Mr. Jokanisi amounts to them having killed him unlawfully. But additionally, the contentions that by the SAPS and the evidence leaders that Mr. Johannes's body was found close to that of Warrant Officer Lepako is manifestly inconsistent with the objective evidence. The objective evidence is that he was found 80 to 100 meters from Warrant Officer Lepako, 150 meters from Warrant Officer Monele. And the post-mortems, in addition.
No, Mr. Bezos, I seem to recall when the copies of the statement were first produced, we did say we thought that the pathologist who did the original post-mortem should be given a copy and asked to comment. I take it the comments from the original pathologist have not yet been received. Is that correct?
No.
The way we'll deal with it, I think, is this way. Save time. When we get those reports, we'll make sure they're circulated. And any council who have comments they wish to make will obviously send them to us in writing. It's unlikely we'll get them before the end of the week. It's unlikely that those who wish to answer will be able to do so for the week. But we will, as you know, we've got until the end of March to do the report. It's going to be quite a steep climb up a very steep mountain, but we've got some assistance. And so during that period, obviously sooner rather than later, we would like to receive responses to these things. We don't know, of course, when the comments, if any, will come, and we don't know how long those who may wish to comment on them will need, but clearly it's no good sending it to us in February, because by that time, hopefully, the report will be largely written, and we will just be proofreading and checking and that kind of thing. But it seems a practical way to deal with the situation.
Thank you, Mr. Chair. I think I concur. Now, Mr. Chair, the further submission we make relevant to Mr. Johannes is the... Okay. Now, Mr. Marty, on the basis that the chair has indicated relevant to it, then we can get to Mr. Marty. We will recall, Mr. Chair, that Mr. Marty was a striker who was shot and killed outside the hut in the informal settlement. Now, we submit on the same basis that you must find that he was shot and killed unlawfully. There seems to be a persistence on the part of the SAPS that Mr. Marty died from a stab wound, because that's what seems to appear in their heads.
I think that point is no longer being persisted in. Initially, it looked like it.
Well, we thought so.
As far as I understand, it's now common cause. If I'm incorrect,
Well,
I'll be
we
correct.
thought so, Mr. Chair, but in paragraph 136.5,
Just say they still persist in their heads.
I see. I'm advised that I'm wrong. We haven't yet got a response from the first pathologist
Yes.
who said it was a stab wound. So I was wrong in thinking that it's now accepted that it's...
yes,
it was
Mr.
a-
Chair. As I say, I mean,
But unless Mr. Semenya can help us. Mr. Semenya, are you able to help us now?
Chair, no, we're not conceding. It's not common cause that it was a short wound.
Mr. Wesley's looking after that part of the case. Mr. Wesley, can you help us? We have the statement of Mr. Semenya. They're not conceding it wasn't a stab wound.
Yes, Chair, what we'll have to do is follow up with the pathologists. There is no further report that says anything new. I'm not sure how we'll...
No, what I've suggested is the new reports that we've got must be sent to from what you can call the second pathologist in each case. It must be sent to the original pathologist, asked for comment. The comment must come back to us, submitted to all the parties, and those who have comments to make on the comments by the first pathologist will have an opportunity to do so in writing. Yes. But as I've indicated, difficult to fix time limit at this stage, but it'll be rather foolish to send them in too late because we may not have time to look at them. So clearly, these are important matters. We want to give careful consideration.
Yes, Chair, what we'll do is we'll send in all the new reports to the particular pathologists and ask for their comment.
well, Mr. Chair, we make our submissions all the same. But we had to record what we perceive to be the position of the evidence leaders. Because we understood Ms. Play to be arguing that on a balance of probabilities, Mr. Marty was shot by members of the police service.
Maybe the evidence leaders approach. But Mr. Semenya for SAPS says he doesn't make that concession. So it's a matter we have to do.
Well, I can only make the submissions, Mr. Chair, but I don't know whether this... It seems, therefore, it is going to be still a contested area. But Dr. Naidu's post-mortem report concludes that the features are, in his opinion, confidently that of a gunshot wound through the thigh and not a stab wound. Says so in so many words. And in any event, when the family made its presentation to the Commission, Mr. Marty's cousin specifically raised the concern that it was alleged that Mr. Marty was stabbed as opposed to having been shot. And insofar as the chair, of course, correctly considered now by the chair, that he had told Mr. Marty's cousin that this should no longer be an issue, pretty much the same way as the chair said, was indicating as much to me. It is clear that even though at the time that impression was not corrected by counsel for SAPS, because when the chair said that it is no longer an issue, whoever was present on the day did not contradict the chair in this regard, and that's the impression under which we had been labeling. We would suggest that to the extent that that was a tacit concession, they should be bound by that concession. And it also appears from Lonmin Security Casebook regarding the death of Mr. Marty that he was shot by members of the SAPS whilst fleeing from the scene of the main confrontation. Blow confirmed this in his evidence. Solness are to deal with the suggestion that Mr. Marty was shot by one of his fellow strikers. Again, this proposition, Mr. Chair, is contradicted by the Lonmin Security Casebook regarding the death of Mr. Marty, because that casebook records that he was shot by members of the SAPS. The possibility of Mr. Marty having been shot by one of the strikers was not canvassed with Mr. Blow or any other witness for that matter. And in any event, there is no evidence to support the allegation that strikers fired at each other on the 13th of August 2012, and or that Mr. Marty was possibly shot and killed by a fellow striker. On the contrary, there is this unchallenged evidence on the record that establishes that the SAPS members fired at him whilst he was fleeing the scene of the main confrontation. It seems, however, all having been said, the evidence leaders are quite happy to make the following recommendation or to make the following conclusion. It is now clear that Mr. Marty was killed by SPS members. You'll find that in their heads of argument in paragraph 1310. We submit, subject to what is still going to be done by open exercise, that your commission must reject the submissions that have been made that Mr. Marty was stabbed. Alternatively, that he may have been shot by one of the strikers as opposed to members of the SAPS. In fact, the commission must find that the SAPS unlawfully shot and killed Mr. Marty. Now, Mr. Sokanyile is the striker whom you know, Mr. Chairman, who was shot across the river. There's been a lot of debate about his fate. The objective evidence, in our view, is sufficient for you to find that he was shot and killed by SAPS members. The only reasonable inference that can be drawn from these objective facts is that he was shot and killed execution style from the other side of the river. And our full argument, as you will have known and you have acknowledged, Mr. Chair, is contained in paragraph 71 to 111 of our heads of argument, and we would really ask you, Mr. Commissioner, and commissioners to have regard to those heads of argument and arguments we made there. We will not repeat them in full. All we want to say, to summarize our position contained there. One, there has been no attempt to justify Mr. Sekwanyile's death in any way at all by the SAPS. And on that basis alone, we submit they must be found to have acted unlawfully in killing him. Further, the objective evidence clearly shows that Mrs. Okanyile was shot and killed unlawfully in the following ways. He was shot 620 meters away from the other side of the river.
From the main confrontation. The main confrontation.
Yes. Or from the main confrontation, yes. And then the distance was 74.4 meters away from the other side of the river. He was clearly fleeing whenever he was shot. He was killed by an R5 bullet to the head. The new PM report by Dr. Naidu states that the entrance wound was the wound to the back of his head, and the exit wound was the wound to his cheek. The previous one had actually reversed these findings. But either way, he was shot in the head by an R95 rifle, which in terms of warrant officer vessels can take out a person's life at more than 300 to 400 meters away. That's why, therefore, our submission is that the only reasonable conclusion in this regard was that this man was shot execution style. He was fleeing and was shot at the head. In our eyes of argument, we submit that the most probable inference was that he was shot and killed by that posse of SAPS members who were led by Lieutenant Colonel Vermaak. And we heard that Vermaak was determined to chase whomsoever he thought had taken hold of their R5 rifle. Now, it may well be that the argument will be put as to whether we are able to establish which member, which commander shot and killed Mrs. Okanyile. We're making an intelligent guess about saying Vermaak's posse, or Vermaak himself was the author of this execution. What is clear, however, from the evidence is that he was unlawfully shot, and he was killed by an SAPS member. So at the very least, Mr. Chair, you must find and therefore recommend that further investigations and prosecutions must follow as a consequence of our submissions. We have submitted that Vermaak's version of precisely where Mrs. Okanyile's body was found is incorrect. This we make in our heads of argument, paragraph 77 to 79. The evidence leaders have argued that this submission is undermined by the fact that the families did not cross-examine Colonel Botha in relation to where Mrs. Okanyile's body was found. First of all, I don't think we have dealt with this submission fully in our heads in reply, and that would be paragraphs 23 to 24. Because we make the point there that Colonel Botha had not even testified, or Vermaak had not even testified at the time that Colonel Botha gave his evidence. And in any event, Colonel Botha does not contradict what we say. We say the evidence leaders have argued that this submission is undermined by the fact that the families did not cross-examine Colonel Botha in relation to Mrs. With respect, the evidence leaders have overlooked the fact that the family's placement of where Mr. Okanyile's body was found is consistent with that of Colonel Botha, across the river and directly in line with the cartridges that were found on the scene. Colonel Femak's version, on the other hand, placed Mrs. Okanyile's body approximately 60 to 65 meters from the position identified by the families and Colonel Botha. Put simply, Colonel Femak got it wrong. There was no necessity to cross-examine Colonel Botha on the issue. In any event, Colonel Femak had not yet given his evidence. So there can be no question of undermining anything. We therefore request your good selves to make the findings and recommendations that are set in paragraph 110 of our heads. These are the recommendations, Mr. Chair. We submit that Mr. Mati, Mr. Joganis, and Mr. Sokanyile were killed unlawfully by the police, and our conclusions are that the following findings must be made. The strikers did not change direction towards the informal settlement. The firing of tear gas and stun grenades amounted to an unprovoked attack by the SAPS against the strikers. It was this attack that caused the confrontation between the police and the strikers. Mr. Mati, Mr. Choganis, Mr. Sokanyile were killed unlawfully, and Mr. Sokanyile was shot execution style from the other side of the river. The Commission must therefore make the following recommendations in that regard. Femak must be investigated and prosecuted for the murder of Mr. Sokanyile.
Do you really mean that? We've had some discussion already about what recommendations we should make in respect to prosecutions. What was contended was we should investigate to see whether there's a prima facie case of a criminal offence by a particular person on the evidence before us. We should refer that to the Provincial Director of Public Prosecutions with a recommendation that the matter be investigated further. The case of cases where the potential accused is a member of the police service, the investigation would presumably be done by IPID. In the case of other persons, investigation would be done by the SAPS. And we would then, and this was put to us, we would then recommend that in the light of the investigations, the material that was before us and the extra material that is obtained, if any, by further investigation, the provincial DPP should then consider whether it is appropriate to prosecute. I don't see how we can make a recommendation that something must be investigated, someone must be prosecuted, because we don't know what the result of the investigation would be. So,
no, I accept that, Mr. Chair.
So I think that your 112 should be paragraph 112
should be modified.
Should be modified in the light of that.
No, I agree.
No, investigate and consider.
Yeah. Well, I mean that would
The
apply.
Human Rights Commission
Yeah.
gave us a very helpful section in their heads dealing with the proper approach
Yeah.
by a commission of this kind, dealing with allegations of criminal conduct.
Yes. Well then, Mr. Chair, the following: Mguye Yende, Sikhweleya, Mkhale, Rekhotso, they all should be investigated on the basis that you have indicated, so that should the investigation bear any fruit and support by other evidence, then the appropriate recommendations should be made for their prosecution.
One thing that has to be remembered is that as far as the people who give evidence before us are concerned, what they tell us can't be used as part of the prosecution against them, unless the prosecution is for perjury, in which case different considerations apply. So it may well be that one could say, in the light of what people have told us, there's a case. But regard being had to the fact that what they told us can't be put before the criminal court, the DPP might well consider that a prosecution wouldn't be successful. But anyway, that's a matter for him to decide, or her, not for us.
No, I mean, we are ready there, Mr. Chair. We're on the same page then. Now, the second, or the further submissions we want to make are with respect to scene 1. Again, Mr. Chair, there's been an extensive debate around these issues, and my sense is that you have been given a fair amount of material to deal with by all the parties. We merely would like to reiterate that insofar as we talk about a trap in scene 1, it is to the extent that that term is used in exhibit KK 49. It's there. And to the extent that whatever it is that Mr. Gotts, on behalf of AMCU, has submitted with regard thereto, we align ourselves.
I go far as to suggest it was a trap. What he contended was that Brigadier Carlitz's intention in getting the Nyalas to park themselves in the formation that we see on some of the exhibits was to channel the strikers down the passage towards the TRT, but he didn't necessarily intend that they should be mowed down by the TRT as they came into sight. In other words, they weren't being channeled towards the firing squad. Mr. Gotts, in fact, said in his submission that it may well be that Brigadier Carlitz simply intended that the TRT people should do the disarming and dispersing of these people. I think that's an accurate summary of his submission. Is that right, Mr. Gotts?
Yes, Chair, indeed. We do use the term trap in our heads of argument, although I didn't use it specifically
to explain
today.
What you meant.
Yes.
Orally by
indeed.
This section that I've endeavoured to summarise.
Indeed.
The question is, did I summarise it correctly?
You did indeed, Chair. I'm just pointing out that we did in fact use the word trap in our heads of argument, but you have accurately summarised it.
Mr. Chair, is one of those shady areas of, well, I won't use the... It's one of those grey areas when we deal with this whole issue of dolus eventualis. If you are going to say Colonel Khalid, in everything that we say in our heads of argument, did, he knows the terrain, he knows that there are these two notions of what a perfect block is. But the effect of what he orders is that there is no passage close at B, at A and B. People get channeled towards a waiting TRT line which has been aligned. Now, what was foreseeable to him? When, in fact, people are lined up in a way or are channeled in a way that would expose them to TRT fire, people whom he knew were armed with lethal weapons. So we can't say there was a direct intention, but what we cannot accept is that it was a function of a haphazard slapdash work by those who operated the plan. If it was foreseeable and he reconciled himself with that foreseeability, then we are not able to say that he did not act unlawfully in the manner in which he gave his command. We say even if the version of the police service were to be accepted, it is clear that the killings at the Kroll were unlawful because the force that the SAPS used was entirely disproportionate to any threat that they faced or thought they faced. We have made the argument time and again that one R5 bullet, and was supported here by the SAPS's own expert, if one of the bullets from the R5 had been directed at the lower limbs, it would have stopped them. We know that the evidence that is set out in our, the evidence for this submission, as I indicated, is set out in our heads of argument, and I read it to you, Mr. Chair and Commissioners. And yet when and I will merely mention them, Mr. Chair, because you have made it clear to us that you are on the strength of what we have detailed in our heads of argument. You have paid particular attention to what we say. All the people who were shot, Mr. Monesa, Mr. Noki, all of them, and I'll just mention their names without giving the details of where on the bodies they were hit. Though in my presentation at the end of my argument, I will try and illustrate this. But the one thing that we are submitting at this stage is that the people who were killed at the Kroll, they were shot multiple times with a fatal wound being to the upper body. Yes. Which is why we're making the point about disproportionateness. If you look at Mr. Monesa's body, if you look at Mr. Noki's body, we had 13 shots, 14 shots. Zibambele's body, Tukuza's body, Lehupa's body, Nteneja's body, all of them were shot in the upper body. Sompeta's body. In fact, with respect to Nteneja, the private pathologist found that the main cause of his death was a high-velocity gunshot wound to his chest and abdomen. The state pathologist did not state what the cause of death was, but presumably, in his view, what he considered to be the gunshot wound to Nteneja's head. Sompeta's body, Ngweyi's body, Yona's body, Mfenyeho's body, Jijas's body, shot to the head, to the left forearm. Mr. Yawa, shot in the back. And in most of these cases, if not all these cases, Mr. Chair and Commissioners, the state and private pathologists are in agreement about the main cause of death. For instance, in Mr. Yawa's case, that it was a gunshot wound to his chest and abdomen. Even Chijas. Now, Mze is a sorry case. Mr. Chaskalson referred both in evidence as well as in his address. He was also shot in the upper body. And there's agreement between the state and the private pathologists. This is the man who bled to his death, with members of the police service milling around and doing nothing. with Major General Naidu chosen not to do that which he is ahead of, to attend to the injured, but deciding to go and enter the fray in Scene 2. And we must be made to believe that this was just an accident. Mr. Chair, in addition to the nature of the injuries, we are in agreement with the evidence leaders. One of those rare moments that we are. When they talk about the disproportionate nature of the firing at Scene 1. No care was taken to shoot at the striker's lower limbs. The objective evidence shows that the strikers continued. The TRT. The TRT shooters, some were calling them shorties, continue to fire after any perceived threat could be seen. But even after, there was a debate that was had between the chair and one of the, I'm not so sure who, but it was clear that even after the first volley, I think it was with Ms. Rue, that there is no justification for any firing at the mine workers beyond the first 3 seconds, even assuming that there was a justification for firing within those first 3 seconds. And it struck me, Mr. Chair, talking about people who subjectively, even erroneously, thought their lives were under threat. There are things that indicate or from which inferences can be drawn, which people do at the scene. I can never forget that every time that first volley of rounds is shot, after the ceasefire command has been given, it is clearly audible that there's someone who says, "I will shoot you. I will shoot you." Now, whether that can be interpreted as an expression of shock or by an expression of triumphalism is a question of debate. But I'll make this a submission, that if there is anything to be inferred from that kind of conduct, it is certainly not the conduct of a person who regrets an erroneous mistake he made as to whether he was under attack or not. It's as though he says, "I'll give you a dose of your medicine." So even if there was a threat or a perceived threat to the TRT line at Scene 1, what the police officers did was absolutely disproportionate to what they could have done. Now, our position, of course, has been very clear and unequivocal. There was no threat in all the ways that we canvass in the heads, and which has been considered in some instances by the SAPS themselves. There was no incident 1, there was no incident 2. And so the scale of things that were used as justification becomes, the scale becomes smaller and smaller. Now, there were those victims who were shot behind and away from the claw. These victims are Mr. Mngongo Pele, Mr. Mchazi, and Mr. Gwelani. Now, Mr. Chair, I think there's been a lot of debate about that before us. We can only say that we are quite amazed that the submission is even made in the circumstances of these deaths. The temerity to submit that these three were clearly among the group of strikers who were attacking the police or could reasonably have been believed were meaning to attack them. There could not have been any innocent individual amongst the group. They all made common cause with Mr. Noki's leadership and utterances that they were to kill the police. Now, this is what is contained in paragraph 178 of the SAPS's head. We submit in that regard that there is no evidence absolutely to support this proposition. It has no base, it has no merit. We would like to submit that this is a desperate and last-minute attempt by the SAPS to escape or to avoid an inescapable conclusion that the strikers never pose any threat to the TRT line, both in terms of the distance where they are found, and that their deaths were therefore clearly unlawful. It is clear from the objective evidence that they were killed unlawfully. Mr. Mchazi and Ngongopele were shot 100 to 150 meters away from the TRT line. Mr. Gwelani was shot 250 meters away from the TRT line. These distances alone, Mr. Chairman, are clearly indicative of the fact that these two mine workers could not have posed a threat to the TRT line. That much was considered by Colonel Classens. And, as my juniors are eager to let me make this submission, they were all killed by a single R5 bullet to the head. And that's very significant. At that distance, an R5 bullet to the head could only, in our submission, be a function of aiming at a particular part in the body, or could be a function of firing widely, irrespective of the consequences of the use of that lethal weapon at your disposal.
I think we've covered the same already in your comments.
Yes.
I think we'll probably just
Now, Mr. Chair, we will say that the failure to render medical evidence in the context of what we have argued is a clear indication of the unlawfulness of the conduct of the SAPS after the injured were shot in scene one, both in terms of that medical assistance having failed, both in terms of the SAPS having failed to provide the medical assistance timeously, and we submit that this is a demonstration of the way in which they have absolute disregard for the sanctity of human life, and would go so far as to say it is the kind of attitude that one would associate with a person or persons seeking revenge. You see, Mr. Chair, it's one thing to say I've never been trained in first aid. The most rudimentary first aid methods, we know it. You don't have to get a degree, you don't have to be trained in any course. If a person is bleeding, you try to stop the bleeding between the heart and where the wound is. You don't have to be qualified to do this. And I cannot be persuaded to accept that trained police officers do not have that rudimentary training. But we see more at the scene. Some of them, kick in the face or trample on people who are injured. And there's that spectacle of the man who is writhing with pain, who dies. Nteneja dies a horrible death. In fact, when his family see how he dies, they get reduced to painful tears. Because he dies in circumstances where people are milling around. Whether or not he would have died in any event is a separate issue. What we see there is this callousness, this absolute disregard for people who have been injured. And again, I will ask the question, is this what we expect in a democracy? That was not a war zone, but even in war, the Geneva Conventions make provision for the treatment of those who get injured in a battlefield. The standards we adopted at Scene 1 are far below what you would expect of any civilized society, let alone a constitutional democracy. For respectfully request you, Mr. Chairman and Chairman and Commissioners Dokota and Hamrach, to be persuaded by the recommendations which we make in paragraphs 412 to 114 of our heads, and on the same basis as before, where we recommend or we make submissions for recommendation for prosecution, we do the same thing. Yes, what we set out there, Mr. Chair, is not something I think we need to read out, because we have argued it extensively as we were, except that we say you need to make the recommendation on the basis of the instructions that Brigadier Kallis gave for the deployment of tear gas, rubber bullets, and water cannons, the instruction for the TRT to open fire, make the appropriate recommendations for him to be investigated.
Mr. Sebeso, there's one point I want to raise with you in relation to paragraph 4.13.6 on page 303. You refer to what happened at Scene 1, and you make the points that you orally repeated to us. And you then say, accordingly, SAPS members are prima facie guilty of murder, alternatively culpable homicide, with deaths of 17 people, and injuries and attempted murder and or assault, etc. Now, the difficulty that we have, of course, is that because R5s are used, we can't link any shooter to any death. The most we can do, as far as individual liability is concerned, I would imagine, would be to say that the SAPS members concerned, if you are correct in the submissions you make, are guilty of attempted murder, because many of them who shot would not have fired fatal shots, because we know I take it only 17 people fired fatal shots, or possibly even less than 17, because there may have been some who fired more than one fatal shot. Of course, if you are correct in your submissions in relation to the planners and the Brigadier College giving order, where there would be a generalized order, would you say, was accompanied by the foresight of possible death, the recklessness as to whether that death would ensue, then of course one doesn't have to prove a direct connection between a particular death and the person you say would be the potential accused. And there, if you are correct in your submissions, a charge of murder would be the appropriate charge to consider. But in relation to the matter dealt with in paragraph 413.6, I take it you'd accept the problem that I've mentioned to you in relation to murder. I was proposing to take 2 quarter to 3. Would it be convenient for you if we took the adjournment now? You could then consider the point I put to you and discuss it with your juniors and give us the benefit of the inputs thereafter.
Indeed, Mr. Chair.
15 minutes. Submission resumes. Mr. Nsibeza, are you now able to deal with the point that arose before the adjournment?
Yes, Mr. Chair. Mr. Chair, there seems to be a view, which I will put to you as a submission, that one never knows what might come out of an investigation. So if we submitted to your good selves to refer the killings for further investigation on two bases. Firstly, that even though there's the difficulty that was indicated with respect to whether you can trace any bullet to who the shooter was because the bullets disintegrate, one can never know what might come out in an investigation. And therefore, if there's the assumption or the finding that those who shot had at least dolus eventualis, or there is a prima facie case that they committed murder on that basis, then there is no reason, even if, as I would submit at the end, the Commission came to the view that the disproportionateness in the shooting of those who became victims justifies a prima facie finding that the shooting was unlawful. Then on that basis, there would be justification to refer the matter for further investigation. Now, secondly, if it is not possible to identify who each shooter was, it's clearly possible to identify who were there. And the doctrine of common purpose should form a sufficient basis to make a recommendation that they all must be taken to have acted in common purpose. I know it's not a doctrine which is endearing itself to the chairman. It may well conjure up the past in trials that the chair has been dealing with in Uppington and all related places where the doctrine of common purpose was very discredited. The Uppington, I don't know, Upping on 20, but whatever the number was. But it is still part of our law, Mr. Chair. And it is one on the basis of which a prima facie view can be formed by you, sufficient for you to refer the matter for further investigation. So those are our submissions. Rather than not do anything, we would recommend that you should, in line with our recommendations.
Arguing then is that, I presume, amounts to this, that there's a prima facie case that all the shooters who were in the front line of the TRT and fired had a common purpose, were parties to a common purpose, to kill some at least of the strikers who were approaching them. So even if you can't say that shooter one shot deceased one, doesn't matter. If shooter one was party to a common purpose with shooters 2 to 60, and the people who were killed by one or other of shooters 1 to 60, then on the common purpose basis, they all can be convicted of murder of all the people who were killed at the entrance to the channel next to the kraal, at C1. That's your case. Not your case, that's your submission.
That's their submission, Mr. Chair. Now, Mr. Chair, Honourable Commissioners, we would like to run and deal with Sin 2. Again, we have said that if the SAPS is not able to establish that the killings were lawful, since there's no onus on the families to establish that the killings were not justified, then the Commission must find that the killings in Sin 2 were unlawful. Now, the evidence before you, and as well as the opening statement by the SAPS, only sought to justify the killings at Sin 2 of Mtizeni, Victim A, Telejane, Victim B, Mr. Mpumza, Victim C, and Mr. Mkonjwa, Victim N. Now, their version is that these victims were shot whilst they were charging at SAPS members. Now, we have argued to refute that. The version by the SAPS in relation to Mr. Mtizeni, Telejane and Mkonjwa and Mr. Mpumza, in the argument we have proffered, is entirely inconsistent with the objective evidence. And our sense is that, in fact, our submission is that the only reasonable inference is that the killings of these people were unlawful. Now, Mr. Chair, we deal extensively, and the constraints of time would only be such that we should refer you to the paragraphs where we deal with our submissions relevant to, firstly, Telejane, Mtizeni and Telejane. In paragraphs 433 to 455 our heads of argument, we demonstrate why the objective evidence does not bear out the self-defense agitated for by the ASPS. SAPS. Now, we also do the same relevant to Kalabile and Pato. You will find those in paragraphs 456 to 477 of our heads. Now, in respect to Mpumza, we converse in paragraphs 569 to 604 or 604 of our heads. And Mkonjwa we deal with in paragraphs 558 to 568. Now, there are, of course, other victims who were killed at Sin 2, and those are Mr. Mangojwa, Mr. Liao, victims DNE respectively, Mr. Mosebetsane, victim G, Mr. Mabia, victim H, Mr. Nokamba, Victim I, Mr. Sapend, Victim J, Mr. Ngande, Victim K, Mr. Kadlela, Victim L, Mr. Pato, Victim M, Mr. Kalabile, Victim O, Mr. Mohai, Mr. Sagalala, or Sahalala, and Mr. Ntswele. Now, relative to those, no account has been given of the circumstances under which they were sought. In their opening statement, the police service appeared to concede, as well as Mr. De Rova, it also appears, that these were caught in the crossfire between the various SAPS units at Scene 2. And our submission is that for the first time in their heads, the SAPS justifies the killings of these victims in the killing zone on the basis of statements of SAPS members. Now, there are two other victims, Mr. Sikhalala and Mr. Now, the statements that have been provided to justify the killings provide no justification at all for the killings. So they had nothing really. The other two victims is Mr. Halala or Sagalala and Mr. Ntswele, who are believed to have been shot at Scene 2 and to have died later in hospital. Now, there's no information about how they were killed. It isn't even known where in the copy they were shot and killed. And the only reasonable conclusion, therefore, is that they were killed unlawfully. And we therefore submit that these killings must be found to have been unlawful because there's been a failure to justify them. Now, the point I'm also, to which my attention is drawn, is all of these died as a consequence of a single or two shots to the upper body of the victims. Hence, the inference is strong that the killings were not justified. Now, Mtizeni and Telejane, we would like to make Mr. Chair, we are trying to avoid having to go through each victim page by page because
all the material is before us. We've got them in full head.
Yes.
As I said, we've read them. We will read them again and again in the time ahead of us. So you don't have, unless it's a particular point you want to stress or highlight.
Yes.
It's not necessary in order to make sure we're familiar with the content of the heads to actually read it to us, because that's being looked after anyway.
Suddenly I feel like Mr. Bezos. Chair and Commissioners, we would like to make the following submissions. As to what the conclusion should be. The first one is that the commanders of the police service must be found to have had ample opportunity to hold the operation after scene one. That much also is said by their own expert. And we would urge that you should find it was grossly negligent in the circumstances for that not to have happened, and that the SAPS should be held consequently to have been liable for the killings at Sindhu on that basis alone. It's an operation that ought not to have taken place at all. The second submission is that there was no attack by the strikers on the members of the SAPS in Scene 2. Consequently, they were not acting in self-defense or in private defense or whatever kind of defense, because they cannot have been reasonably believing that their lives or the lives of any of their colleagues were in danger. Fourthly, the response of the SAPS members to whatever threat or perceived threat they might argue that they were under was disproportionate, and therefore whatever they did exceeded the bounds of any legitimate defense that is sustainable at law. Fifthly, insofar as they are on that basis, on our submissions, and if our submissions are accepted, there is a prima facie case which this Honorable Commission can recommend to be investigated and, depending on the investigation, pursued for purposes of preferring charges of murder, alternatively culpable homicide, attempted murder, and or assault with intent to do grievous bodily harm for the deaths of the 17 people in Scene 2, and as I believe Mr. Mpofu will make a submission for the injuries to those whom he represents at Scene 2. There is also a basis on which you can make a recommendation for civil liability of the South African Police Service if further investigations bear out what we consider to be a prima facie case that can be established against the SAPS. We also request your commission to recommend a further investigation of the following members of the SAPS and the prosecution thereof, if that is possible. And the members would be Brigadier Kalitz, Major General Naidu, Colonel Modiba, Captain Kidd, and the individual shooters, Constables Bachane, Butelezi, Mabe, Batsi, Mahlatsi, Palelo, and Litswalo.
What you say in paragraph 610.3 is that the individual shooters at scene 2 should all be charged, and the names you just read out are the names of some of those shooters.
Including?
You say including, and I don't think you've mentioned what you say in paragraph 610.1, that in addition to Brigadier
Commanders
College,
in the JOCOM.
there, the commanders in the JOCOM, you say, should also be
Yes.
investigated to see whether they could be prosecuted for failing to halt the operation after scene 1.
Indeed, Mr. Chair.
Where are we?
Before I go to consider loanmen, I've lost my file. Okay. Thank you, Mr. Chair. Mr. Chair, just for the sake of completion of the point that I made earlier on, I'm just trying to make sure that I don't run out of time before I've made the point. What I wanted to, when I talked about clips, the clips that we'd like to play, I just wanted us to see if we can show up
Before we get to clips, may I ask you, are any warnings required? I don't know what clips we're going to see.
No. The first
If
clip
there are
is
any
the one.
clips that require warnings, you must please let me know.
Not yet. That will come 15 minutes before my time is up. The clips is relevant to the very first point I made, Mr. Chair, and it is triple T4 minus shot down. We started 1321 into the video to 1341.
Which club? TT4 is split up. It's VTS. We've already told them.
It's VTS something.
VTS.
Can we play that clip, please?
Did you tell me? Mandera.
Well, it looks like nobody's ready with this.
Oh, he's not aware.
Where is Craig? And is he aware that we want him to play something? He's not even in the chamber, I believe.
He's there.
While the
Yes.
operator is being fetched, maybe you can go on to another point.
Yes,
When
yes,
he comes, you can
Mr. Chair.
revert to the video.
I agree. Now, yes. Mr. Chair,
Oh, they're ready.
oh yes. Is that 1321?
Yes, that's the one of Rana Plaza.
Okay.
Like 1307, from what we can see.
Yes. Sound.
Mine workers have always had to put up with harsh living and working conditions. Cyril Ramaphosa was determined to change this. Under his leadership, workers were led into mass strikes and direct confrontation with the white
Mr.
community.
Chair, it is
He was
not
for me
achieving the
a
objective
vital
if
and
it has no
important
sound.
person in the birth of the new South Africa.
There's no such thing as a lip.
Sure. My time. Mr. Chair, the clip can be played after after I've done my bit. I think, yeah, Craig, just never mind about the clip now. Let me just go into something else. Mr. Chair, we have made some on lawnmen, and can I quickly go through those?
.414 of your heads, Part F, beginning with paragraph 611. Is that right?
Yes, Mr. Chair. Where we submit that, I mean, the families are very, they're quite unhappy about obviously the employer, the conduct that the employer adopted towards their families or towards those who died whilst they were serving under them. Our submission is that lawmen should be held civilly and criminally liable for the deaths of the family's loved ones. Particularly, we submit that lawmen wanted SAPS to break the strike and lobbied and colluded with SAPS to achieve this. And we rely on what is set out in the paragraphs 610 to 628 of our heads of argument in this regard. We also refer to the interrogatories, Mr. Chair, that we handed up this afternoon. Those were submitted to Lonmin, and the response that was received on the 24th of October 2014. And on the basis of those, we make the following. Firstly, the families dispute that the only undertaking that was provided on the 9th of July 2013 was to find employment for only one family member per family. The undertaking that the families understood was that the families would not go hungry. And this was understood by the families to be an undertaking that lawmen would assist them to put food on the table for their families. Secondly, we submit that lawmen should assist those families whose loved ones were in the process of building them houses by undertaking the expense of completing those houses. Thirdly, lawmen has delayed unduly in upholding its undertaking to ensure that one family member per family should be given employment at lawmen. It must honor this undertaking without any further delay. Fourthly, lawmen's position of not providing any assistance to the Telejane, Gwelane, and Pumza families on the basis that their loved ones were not lawmen's employees at the time that they were killed is, in our humble and respectful submission, a very cruel and arbitrary decision, very, very unfeeling position to be taken by an employer. Loanmen, in our view, and this is our submission for your recommendation, should provide assistance to these families, as it does to the other families.
We must have the interrogatories and response made exhibits.
Mr. Chair, I would hope that those interrogatories and the responses are given an exhibit number.
Indicated that Ms. Pillay will look after that. She report to us first thing tomorrow morning what the results
Indeed,
of this
Mr.
exercise
Chair.
are.
Chair, I have allocated an exhibit number. It's quadruple Z 38.1.
Sorry, perhaps you can give it as in writing if you don't mind tomorrow morning. Time is short, we want to.
Yes.
Mr. Beza wants to squeeze everything into the time available. But thank you. I mean,
The submission, the reasoning in our interrogatories.
In fact, when once one pays attention to what is contained in the interrogatories, one has a context.
Beza, I must tell you, we haven't got the interrogatories, we've got the answers. Now, in some cases, the answer is quite full. But take paragraph 10, for example, add paragraph 20. The answer is yes. You know, there are others. There's another one that says no. You know? So we would like the interrogatories as well, please. But that again can be attended to overnight. But you don't have to attend to it now. We certainly will study the interrogatories and study the answers.
I don't know how it has been done, but my attorney insists that there is.
You see, what's happened is we've been given the answers.
Oh,
But
yes.
we've been given Longman's responses to the family's interrogatories. But we haven't got the actual questions themselves. What we've got is a letter from Seri to Ms. Lepage.
Dated the 23rd of October,
Letter 23rd
2014.
October, simply saying we gave you these interrogatories, you haven't answered them, we haven't got a meaningful response,
Oh, I
we've got
see.
to file our written submissions. What's wrong with you? Get on with it. That's a summary of the letter. But we haven't actually got the interrogatories.
interrogatories
But that's something
themselves.
that can be attended to.
Okay.
Let's not waste your
All
valuable
right.
remaining time on that point. It can be sorted out.
Indeed, Chair. That will be attended to, Chair. Yes. Now, we have recommendations set out at paragraphs 49.2 and 49.3 of our replying heads of argument, which we would like to draw attention to. Okay. And the recommendations in our reply heads, Mr. Chair, are that you should find that loanman is liable to compensate the dependents of the deceased for loss of support. And that you should find that the senior executives of loanmen can on a prima facie basis be investigated further, and depending on the investigation, that they can prima facie be charged as accomplices to any such crimes as may have been committed by the SAPS on the 16th of August that resulted in the deaths of 34 strikers. And I'm sure Mr. Mpofu will make also the recommendation.
That in as far as Longman is concerned, it appears from paragraph 611 of your heads that the families submit Lonman responsible for deaths of their loved ones. And you go on to say in 612, Lonman's responsibility is set out in full in AMCO's heads of argument. We make common cause with these submissions. Don't consider it necessary to repeat them. So we already had heard that from AMCO. Then you go on to make the point in 613 and following that Lonman wanted SAPS to break the strike and lobbied and colluded, as you put it, with SAPS to achieve this. You then set out the evidence in certain paragraphs. And then at the very end, you contend, it looks like paragraph 630, that Lonman is responsible for the deaths of our loved ones. And then you deal with the undertakings, which is the point over the interrogatory. But your contention is Lonman is responsible for the deaths of the loved ones of your clients, the family, and therefore you would have your clients would have a dependence action, a dependent claim against Lonman. And in as much as, on your argument, I take it, SAPS and Lonman are jointly and severally liable, you would only look to each of them for half, I would imagine.
That's the argument. Now, the only subject I would like to touch quickly on is was provoked by Commissioner Tokota, who wanted to find out about Muti. I don't know whether he's still keen to have a debate. But what we found, Mr. Chair, is Exhibit KK10, which is SABC's own analysis of the post-mortem reports. And what we found was interesting there was the fact that it discloses that 2 of the dead people had fresh scarification marks, 6 had fresh traditional healer marks, 11 had traditional marks, and 12 had no marks. Now, only 8 of the dead on the 16th had fresh Muti marks. Of the 8 with fresh marks, 3 died at scene 1. Now, Mr. Ngongopele was killed approximately 90 meters away with injuries that suggest that he died where he was shot and therefore was not part of any alleged attack. Now, this leaves only 2 minors with fresh markings in scene 1. So insofar as there would be an argument that the marks were indicative of Muti having been applied to these people, with whatever effect it is argued that achieved, it seems to us on the basis only on the basis of this analysis, there would be no way to account for the other 15 people other than the 2 who were found with fresh marks to explain whether or not they acted as a consequence of Muti. And I say this also bearing in mind what Professor Lamla seems to have given his expert opinion on the relevance or otherwise of what the MUTI was supposed to achieve. There would also be Makidiwana, who was being cross-examined by Mr. Ngalwana, who was asked to consent to a medical examination to establish whether he had MUTI markings from August 2012, when there was a big argument as to whether you can age the markings. Now, on page 6374, line 18, the chair seems to explain that there are three possibilities. One is that the doctors may say they can't say what age the mark is. Secondly, they could say they were more recent than December 2011 and probably done about August 2012. Thirdly, they could say they could be that they were consistent with their having been done in 2011. So we want to argue that there is insufficient support for any argument that is advanced that these people were under the influence of MUTI. Because on their own analysis, it doesn't seem to be a correlation between fresh marks, because we must take it that if it was as a consequence of the perceived MUTI that they received closer to the 16th, then the fresh marks must be the ones that must be relevant. Besides, as Mr. Tawata will know, African people have these marks for all kinds of things. Some people get their scarification marks when there's about to be a big occasion at their homes, and they go and they get scarification marks. So there is just no link, there is no sufficient evidence to bear out that those who had marks must have been therefore people who had undergone Lama ritual, or the rituals, according to Mr. X, for purposes of causing them to be invincible or invisible or both. So I would submit that on the available evidence, there is not a strong case to support that MUTI was responsible for anything else, because it is not explained how it caused any perceived belligerence on the part of the mine workers, the nature of which it could be relied upon for what was perceived to be the conduct of the mine workers. Much less can it be relied upon as an indication that the mine workers, as a result of the MUTI, decided to attack the police. Our position is that there's not been any attack that has been shown to have existed, even subjectively. But if one accepts that the police may have believed that they were being attacked, particularly in Scene 1, they clearly cannot link what they perceived as an attack to the application of MUTI. Now, Mr. Chair, I will definitely now need a warning to be given for my final submission, which will be...
Can you perhaps give the warning yourself in also?
Kuthiwa mandinixelele uba kukho ifoto esaziveza apha zaba bantu badutyulwayo. Ndiyayazi mos uba niyoyika or niyafilish ninento ethi hayi noko izawusikhathaza le nto sayibona. Ndaweni yobana nilile apha mhlawumbi ngeske sizicenge thina singazuva kakuhle. Sikhona ifoto apha esaziveza sabantu abadutyulwayo kuba sifuna ukwenza uba ke niqinile nonke hayi ke akho ndlela sizawuqhubeka.
One appears to, well, one person I think left,
Yes.
and there's another lady going.
Yes.
Two ladies.
Does he know what to put up?
Can we put up the presentation that has been indicated to? Forget about the Deputy President for now. Now, Mr. Chairman, before we go through these graphics, our submission is the following. The gravamen of what we perceive to be the justification for those who were killed seems to be that the police acted in self-defense. Now, we have contested that. We have argued that on a wide range of reasons, it cannot be so. We have also submitted that if we accept our proposition that the use of lethal force, the use of violence by a gangster should be different to the use of similar force if it is used by a law enforcement agency. Because the responsibilities of these two entities are different. Then it must be accepted that in a society where certain foundational values have been cherished, in a society where there has been a conscious effort since the dawn of democracy to even change the manner in which our police service is trained, then there is a lot that is expected by these families in the way in which the police service will react even to a perceived threat. Because their duty, even in the face of danger to themselves, to other human beings, threat to property even. Theirs is to make sure that what they do in defense of property, of themselves or of others, can never be so disproportionate as to defeat any understanding as to why it could have been done. Because they are law enforcement agencies. What we had on the 16th was not a warfare between gangsters. It was a tense situation where they were striking mine workers armed with assegais and pangas. To date, we have only seen one revolver in scene one that can be attributed to the mine workers' pistol. On the other hand, we have a line of specialized forces. You now know that the weapons they carried on the day, one single shot was capable of killing a person, as it did on this day, 250 meters away. Now, in the case of Gwelani, in fact, somebody in my team says, in order for us to have a sense of scale, 250 meters is the length of 2.5 rugby fields. Soccer, regulated soccer fields. So if you can imagine one soccer field, second soccer field, and a half of a soccer field. And at that range, Gwelani was shot dead. One single shot to the head.
Worried, Mr. Bez, about the time. How long are these pictures going to take? You haven't got much time left, so anyway, I'm just warning you.
Well, it's about, I don't know how they are going to be. It's not long. It's just 4 slides.
There's not a problem then. All right. You've got 5 minutes, I'm told. Yeah, all right. 4 slides with just over a minute per slide, okay.
Put up. That's slide 1. Go back, please.
That's Mr. Takuza. It reads killer bullet, 1 high velocity bullet to the head. I take it he was 42 years old. That's what the meaning of the 42, the first line is.
Next one, please.
Next one is Mr. Jazi, age 26, killer bullet, 1 high velocity bullet to the head.
Next one.
Next one, Mr. Pato, age 35, killer bullet, 1 high velocity bullet to the neck.
Next one.
Mr. You have to pronounce it for
Ngongopele.
me. How do you pronounce it?
Ngongopele.
Pele.
Yes.
Age 31, killer bullet, 1 high velocity bullet to the head. Then the next slide reads, what about Mr. Noki?
Yes.
We have a picture of him in his green blanket. And then we have a sketch of the various injuries to his head.
Now,
sketch of the injuries to his body, the wounds.
Now that's the number of bullet wounds, Mr. Noki. The man in the green blanket, after he had been shot at less than 30 meters away with R5 rifles. That was the nature of his body.
Now we have 14 high-velocity bullets.
That was Mr. Noki.
That's Mr. Noki. 2 head and neck, 3 front left lower leg, left thigh, elbow, right buttock, back right thigh, back right calf, left lower leg, rear lower leg, right thigh.
Now that's his head, Mr. Chairman.
Yes, his head is depicted lying, looks like on the green blanket, with a number of frightening-looking wounds on his face.
That is the head that had been reduced to that stage in less than a minute. From the head and the smiling face which you saw before he was killed. And we ask is this: can this all have been in aid of self-defense? Whether it is putative, whether it's in defense. You know, Mr. Chair, to state the obvious.
Go back to the original picture of him
Yes.
smiling in his green blanket in front of the copy.
To state the obvious, we all live in this country, and we all rely on the police service for our security and protection. And whenever I have got threats to my property and my life, and I have reason to call the police service to come and deal with the threat, and let's assume for once that the threat was against each one of us, and the members of the police service perceived that they had a duty to defend us against the perceived threat. I want us to do a soul searching and find out whether, if the threat is 30 meters away, the only way an officer or the SAPS would find that to deal with that threat, and the threat is a spear and an assegai, it is to blow half of the face of that perceived threat in the way in which these photographs have shown you. One single shot, a person's face is shattered to smithereens. Is that what can be justified on any basis in a democratic constitutional state? I have no doubt that even if it was in my personal safety defense, even if a member of the SAPS was acting in my interest, I would never find it was justified for them to use high velocity firepower to remove a perceived threat 30 meters away in that fashion. Not in my name. It should not be in our name as a society. It should not be in the name of this commission, that this commission has sanctioned the disfigurement of persons in that fashion. It should never be in the name of our democracy, not in the name of the Constitution. It just should not happen. Those are our submissions, Mr. Chair.
Thank you, Mr. Sibeza. We will now adjourn until 9 o'clock tomorrow morning, when Mr. Mpofu will have returned and he will address us on behalf of the injured and arrested people, followed by Mr. Tip.
We are so grateful. He's going to reflecting going back in his place.